With the bailiff. Previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes, the court on restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but she's on probation right now in Sutton County, correct?
Yes.
I have been for 2 years.
Right. So do they know about this case? And what has happened over there, if anything?
Nothing. I'm still continuing on my deferred. Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait.
All right. Welcome to a courtroom situation that starts like a routine plea and sentencing and quickly turns into a full-on warning siren. We've got Crystal Boen, also referred to here as Miss Vogen, standing in front of the judge after pleading guilty to a state jail felony theft. The deal on the table sounds straightforward. For years deferred probation, a $1,000 fine, and restitution around $9,400. But here's the problem. The court isn't just looking at the plea. The judge is looking at the pre-sentence investigation report. And when that report shows page after page of criminal history, it changes everything. Because deferred probation is basically the court saying, we'll give you a chance, don't blow it. And the judge is already signaling she's not convinced this is someone who can handle another chance. You can hear it when she starts counting out the cases and the felonies. Because at a certain point, it's not about one theft. It's about a pattern. Then the restitution starts looking messy too. Was it $9,400? Or is the total actually $10,000 with extra withdrawals and transactions? That matters, because restitution is about making the victim whole, and courts take that seriously. And the defendant tries to bring up nursing school, like that's the exit ramp. But the judge's question is brutal and real. With this kind of history, is that even realistic right now? So here's what to watch for. This case is not going to turn on the theft alone. It's going to turn on credibility, accountability, and whether the defendant can keep her mouth and attitude under control long enough to not sabotage herself in real time.
I had to wait to see.
Are you really going to be able to go to nursing school with this type of criminal history?
Yes, because I haven't been convicted of it. I'm a CNA now.
Where do you live now?
In Houston.
A few moments later.
$2,400, but then that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct?
And that would have been added on, I don't think that's a bank fee, I believe. I don't think that.
Well, it says $500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the card.
Okay. So possibly the other person that was involved did that?
Only thing we knew about
That
was
was
like 400 that was in the bank.
I wasn't aware of Your Honor when we did it and got the, when I got the PSIs, I was notified if I was in the cash route. But if it was a withdrawal, then that would be her responsibility joint and separately. So
Right, it says, so
that's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, 94 from inside the bank, 500 from an ATM, and 100 from a Cash App transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of
I
the,
don't have the other cat of another person, Your Honor. This is one that's the charge. I'm not posting on there. But she's responsible.
yeah. So I mean, if there was another person, and you didn't give that information, then that's, okay. Apparently the cops didn't either, so.
She went in the bank, she was the one that called size, whether or not she had a copy from the backside, not to my knowledge.
And hold on, so the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County?
Yes, ma'am.
Okay, and so it's the state's position to go forward with the agreement?
I understand the court's concern, and the state has the same. Like I said, our initial deal was to get some of the money back on our victim, however, we
So,
understand.
all right, so here's what I'm going to do, Ms. Vogen. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly. I'm not. I can't. There's no way. It has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing, so. You do?
No, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 here and one back here.
Okay, you have lots of them that were at the same time for different offenses.
And I was never convicted, never charged.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, theft, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm gonna run out of fingers. March, another one, theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit, and that's the 10-year probation that you're on in 5 different cases.
Okay.
That's not correct.
No. Okay.
So how many cases are you on probation for in Sutton County?
It all ran together. So
I understand it all.
It's one.
It doesn't run, but that's not
This is
how.
the courtroom moment where everything flips. The judge rejects the plea agreement and resets the case, meaning the defendant just lost the clean, deferred probation path, at least for now. And why? Not because the judge woke up choosing violence, because the judge is staring at a history that screams, probation hasn't worked before, and a defendant who keeps pushing back like the rules are negotiable. You can literally hear it when the judge corrects her. When it runs together, that's not how it works. That's the court saying, you don't understand what you're under, and you're acting like you do. And then, here comes the self-sabotage. The defendant's reaction is immediate panic mixed with attitude, and that's deadly in front of a judge. The courtroom doesn't care about what you need to move, what you need to do tomorrow, or what your plan was. The judge cares about one thing: respect for the process and ability to comply. Because if you can't control your mouth for 5 minutes in court, how are you going to follow probation terms for 4 years? So let's ask the audience. Have you ever seen someone talk themselves into a worse outcome? Because that's exactly what this looks like it's heading toward.
But that's not how it works.
yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not gonna help.
It don't matter. My life's going on.
Well, looks like you did that, not me. I'll see you in 3 weeks.
It was at this moment that she knew. She fucked up.
Come on, hold on, get her, don't let her go. Come back.
I heard bullshit.
Everybody heard it.
You're bullshit.
Come back.
Sure, lawyer.
I told my lawyer he was bullshit. I didn't say this.
You don't talk like that to anybody in this case because he didn't do this either, you did.
He got me the plea.
He did get you, he did a great job. I'm gonna find at this time that your bond is not sufficient because of your attitude and because of your criminal, because of your,
I gotta go to work. So I'm gonna lose my job and everything too?
Well, maybe you shouldn't cuss at your lawyer, maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're gonna make it worse. You're just gonna make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. Let's see, can you All right, I'm going to set your bond at $25,000. Go back with the bailiff.
So here's what just happened. In plain courtroom terms, Crystal Boen / Miss Vogen came in expecting a deferred probation deal on a state jail felony theft, fine, restitution, move on. But the pre-sentence report and the criminal history completely changed the judge's risk assessment. The court wasn't comfortable signing off on straight probation, with a record that includes multiple felonies, repeated probation history, and unresolved concerns about accountability, especially when the restitution details didn't even line up cleanly between $9,400 and $10,000. Then came the turning point. The judge rejected the plea agreement and reset the case. And instead of regaining control, the defendant spiraled, disrespect, emotion, and a courtroom outburst that the judge interpreted as attitude and instability. The judge made it clear, your lawyer didn't do this to you. You did. And because bond is about making sure you return to court and keeping the community safe, the judge found the existing bond insufficient and raised it to $25,000, sending her back into custody. The lesson is harsh but real. You can lose a deal in seconds if you show the court you can't follow directions or take responsibility. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.